I now give the floor to Professor Oral for her presentation on the duty to cooperate under Part 12 of the UNCLOS regime. Nilüfer, the floor is yours.
Thank you so much. And I start, of course, by giving my sincerest thanks for the honor to be invited to this conference and be on a panel with such distinguished colleagues. I thank, of course, the Ministry of Foreign Affairs of the Republic of Korea, the Korean Society of International Law, and the International Tribunal for the Law of the Sea. So the 1982 Law of the Sea Convention was indeed an historic development for international law of the sea, for international law actually, and in particular for the protection of the marine environment. Beyond simply codifying existing rules of customary international law, the convention established a new and extensive legal framework for oceans and marine governments at the global level. And threaded throughout its provisions, we find the duty of cooperation for states, in particular, cooperation for the protection and preservation of the marine environment, including the conservation of living resources. It is among one of the most important developments for modern international environmental law and the law of the sea. Indeed, in outlining the historic importance of the 1982 Convention, Professor Scheiber and Professor Karen from Berkeley Law remarked, quote, "General concepts such as duties to cooperate have been incorporated in explicit ways into important areas of oceans law to an extent almost impossible to have imagined when the UN opened its first formal meeting on the law of the sea. The duty to cooperate is not, however, restricted to activities that are solely under the jurisdiction and control of states, but also extends to areas beyond national jurisdiction. Indeed, in its advisory opinion to the request from the Sub-Regional Fisheries Commission, the International Tribunal for the Law of the Sea stated that the obligation to protect and preserve the marine environment under Article 192 applies to all maritime areas. Moreover, as Judge Kulik has just said, the tribunal also stated in its decision granting provisional orders in the Southern Bluefin tuna case that the conservation of living resources of the sea is an element in the protection and preservation of the marine environment. Now, my presentation will focus on the duty to cooperate to protect and preserve the marine environment in areas beyond national jurisdiction under the new agreement that is being negotiated for conservation and sustainable use of areas beyond national jurisdiction. I have to say, it's too long a title. So we say BBNJ agreement. Part 12 of the 1982 Convention is the first comprehensive global regime for the protection and preservation of the marine environment. Indeed, I can say nearly 40 years after its adoption, there really still is no parallel global treaty that applies to the protection and preservation of the marine environment. The Convention addresses the rights and obligations of states in quite detail for those parts of the marine environment that are under national jurisdiction. Without question, the creation of the exclusive economic zone that extended coastal state sovereignty rights up to 200 nautical miles from the baseline where the breadth of the territory is measured, was a major advancement for the protection and preservation of the marine environment. However, today, much of the ocean area, still some 64%, remains as high seas that is lacking a coherent and harmonized legal framework. That is why the decision of the United Nations General Assembly in adopting Resolution 72-249 is of much importance. In the resolution, member states decided to convene an intergovernmental conference under the auspices of the United Nations to elaborate the text of an international legally binding instrument under the 1982 Law of the Sea Convention on the conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction. Now, like the Law of the Sea Convention, it is also a package deal. The package entails area-based management tools, including marine protected areas, environmental impact assessments, capacity building, and the transfer of marine technology, and lastly, benefit sharing of marine genetic resources. Resolution 72-249 also had provided for the convening of 4 intergovernmental conferences between 2018 and 2020. 3 sessions have been completed, but the 4th session, due to the pandemic, had to be postponed, and I believe now it's at the end of August in 2021. When adopted, the BBNJ agreement will be a landmark achievement. Importantly, it will fill a gap in UNCLOS and provide a detailed legal framework for states to cooperate to protect and preserve the marine environment in the high seas and fulfill the various related obligations to cooperate under the 1982 Convention, as I will next explain. The duty of cooperation features as one of the core components of the obligations of states under the Convention. In relation to the marine environment, Article 192 obligates all states to protect and preserve the marine environment. And as I stated earlier, it is an obligation that applies to all maritime areas. Now, Article 194 imposes an obligation upon states to take individually or jointly, as appropriate, all measures consistent with the Convention that are necessary to prevent, reduce, and control pollution of the marine environment from any source. The obligation to take measures jointly is also a form of the duty of cooperation. While there is not an express reference to cooperation in Article 194, plain and simple reading of the term jointly necessarily includes cooperation. Also, Article 194, paragraph 1 is not restricted to areas under the jurisdiction or control of states, but has a general scope of application that would include the high seas or areas beyond national jurisdiction. This is evidenced by comparing the scope of paragraph 2 of Article 194 that specifically refers to activities under the jurisdiction or control of states. Now, in relation to the BBNJ agreement, when adopted, particular attention should be given to paragraph 5 of Article 194 concerning the obligation for states to take all measures necessary to protect rare or fragile ecosystems, including the habits of depleted, endangered, or threatened species and other forms of marine life. Paragraph 5 is especially relevant to the new BBNJ agreement as it applies to areas within and beyond national jurisdiction. Thus, the obligation in Article 194 is for states to, 1, act jointly, and that includes to cooperate, and to take all necessary measures to prevent pollution and to protect rare or fragile ecosystems and habitats and other forms of marine life that are endangered or threatened. We know from scientific information, such as the First World Ocean Assessment, that much of marine life would fall under this provision, not the least of which are coral reefs. According to the very recent first IPBES Global Assessment Report, almost 33% of reef-forming corals and more than a third of all marine mammals are threatened. Next is Article 197 of UNCLOS, which establishes the duty of states to cooperate either at the global or regional levels, directly or through international organizations, to formulate and elaborate international rules, standards, and recommended practices and procedures for the protection and preservation of the marine environment, taking into account characteristics, regional features. Once again, there is no jurisdictional limitations in Article 197. It applies in areas under and beyond, within and beyond national jurisdiction. The decision to develop an internationally legally binding instrument by the General Assembly under Resolution 72-249 is a procedural implementation of the duty of states to cooperate through an international organization, which in this case is the United Nations. Judge Kulik has provided an excellent overview of the jurisprudence on the procedural components for the duty of cooperation for protection and preservation of the marine environment. These would also apply to areas beyond national jurisdiction. In its current draft version, the BBNJ agreement includes provisions for consultation, exchange of information and data, possibly through a clearinghouse mechanism, several different provisions for environmental impact assessments, as well as for monitoring and assessment of risks. Moreover, on the substance, necessary measures would include, for instance, the designation and management of marine protected areas, together with the requisite standards and international rules. In the current revised draft BB&J text agreement, Article 15 details international cooperation for measures such as areas-based management tools, including marine protected areas. Thus, in areas beyond national jurisdiction, where no state can exercise sovereignty or sovereign rights over marine space, the duty of cooperation becomes essential in fulfilling the mandate of Article 192. The BB&J agreement, when adopted, will not be the first implementing agreement under the Law of the Sea Convention that provides a detailed framework for the duty to cooperate. The 1995 Fish Stocks Agreement sets out a detailed implementation agreement for the duty to cooperate in the management of straddling and highly migratory fish stocks under Articles 63, Paragraph 2 and 64, Paragraph 1. Each of these provisions mandates states to cooperate either directly or through an appropriate international organization, language that is similar to Article 197. Now, the duty of cooperation in relation to the protection and preservation of the marine environment in areas beyond national jurisdiction should not be restricted only to Part 12 of the Convention, and Judge Kulik has already raised some of the relevant provisions. Science and technology are core to the measures under the BB&J agreement, especially in relation to area-based management tools, including marine protected areas and environmental impact assessments. Part 13 is specifically devoted to marine scientific research. Now, while on the one hand, Article 87 includes the freedom of all states to conduct marine scientific research, there is also the concomitant general duties that apply to all states, which include the duty of cooperation, as I will now explain. Article 242 of the Law of the Sea Convention imposes an obligation for states and competent international organizations to promote international cooperation in marine scientific research for peaceful purposes. In addition, Article 242 requires that states and competent international organizations cooperate, and again, this was a point already raised, through the conclusion of bilateral and multilateral agreements to create favorable conditions for the conduct of marine scientific research in the marine environment, and to integrate the efforts of scientists in studying the essence of phenomena and processes occurring in the marine environment and the interrelations between them. Favorable conditions should be read to include that scientists in all states have the capacity, access, and opportunities to conduct marine scientific research that will benefit the protection and preservation of the marine environment in all maritime areas. This requires cooperation. Article 244 sets out the obligations of states to share scientific publications and to disseminate information on proposed major programs and knowledge resulting from marine scientific research. States are required to act individually and in cooperation with each other and competent international organizations to actively promote the flow of scientific data and information and the transfer of knowledge resulting from marine scientific research, and this, of course, in particular to developing states. And there's an important capacity building component to this. Now, one part of the convention that is somewhat forgotten is Part 14 on the development and transfer of marine technology, which also includes capacity building. It is quite relevant for the protection and preservation of the marine environment. In Article 266, states either directly or through competent international organizations are under a duty to cooperate in accordance with their capabilities to promote actively the development and transfer of marine science and marine technology on fair and reasonable terms and conditions. Now, marine scientific technology provides the means by which to conduct marine scientific research and to assist in taking the necessary measures for the protection and preservation of the marine environment. The link between marine technology and protection of the marine environment is expressly listed in paragraph 2 of Article 266. There, states have an obligation to promote the development of the marine scientific and technological capacity of states, particularly developing states, and we can't forget the landlocked and geographically disadvantaged states, with regard to inter alia, the conservation and management of marine resources and the protection and preservation of the marine environment. Now, Part 5 of the current revised draft text of the BBNJ agreement details the implementation of Part 14 on the transfer of marine technology for areas beyond national jurisdiction. So I now come to my conclusion very briefly. The new BBNJ agreement, when adopted, will fulfill the obligation of states to cooperate at the global level to protect and preserve the marine environment in areas beyond national jurisdiction, as provided for in Part 12, but also Parts 13 and 14. Thank you very much.
Thank you very much, Professor Oral, for this presentation, also for sticking to the time. Listening to you carefully, I was also wondering whether there would be room for the ILC to do some work on related topics, not on the BBNG, of course, but on related topics. Maybe that's a thought for the future, but I know you are already very busy with the Commission.